started. Now we are ready to get restarted. So we're going to, this second session, it was inevitable that issues would creep from session to session. I think probably that's a good thing in a lot of ways because it provides some continuity in the conversation. When I initially read this set of papers, I thought this set was a little bit more economic than the first set, but of course, as a result, the first set got into economics very quickly. So I won't try to characterize what this set of papers does. In terms of the order, I'm going to go basically in the order in which you have it on the program, with one exception, which is that David, which I guess is alphabetical, but I'm going to jump David up to follow Patrick immediately because they're obviously co-authors. But other than that, after Patrick and David, then Albert, Michelle, Caroline, Kunibert, and Tom. So, Patrick, why don't you start us off?
Thank you. I would like to start off with something that's actually not in the paper, but occurred to me in response to the first panel and to Dan's first remarks. And a number of historical episodes have been mentioned and referred to in the first panel. I would like to bring up a historical episode which doesn't naturally fit into the odious debt question, but I think is relevant to the question of the costs one is trying to address with an odious debt or odious regime policy. And the historical example I have in mind is the end of World War I and how the Allies treated Germany and the new Weimar Republic, and how, as many historians have argued, how the Allies have imposed far too heavy sanctions and far too heavy reparation duties on this new republic, very fragile republic, coming after the empire, and basically undermined from the beginning the political sustainability of the Weimar Republic. But that's the kind of cost one should keep in mind when addressing this question of odious debt. You can imagine how you can really give. There can be situations where you allow a new democratic regime enough breathing room to get started and to survive with a policy like that. Anyway, so I don't want to take too much time, and I should let David talk as well. Let me just start off with our paper and say our initial thoughts and how we came to our conclusions and our views. And so we were aware of this debate on odious debt, having written on and participated in the debate on sovereign debt restructuring. And one of the points that people made, which we took seriously, was that one concern with an odious debt policy and doctrine is that it brings in more uncertainty into sovereign debt markets and may give rise to higher cost of borrowing for all emerging market sovereigns. And so that that's an important cost to bear in mind. But we thought that, on the other hand, there are, unfortunately, in the world, odious regimes, really terrible regimes, and one has to do something about them. And, the UN, for example, tries to address genocide situations through, at the most extreme, military intervention, but also through economic sanctions, even financial sanctions. Well, to the extent that we want such policies and such policies are desirable, it seems odd to exclude debt from this kind of policy and not to allow for the extension of sanctions to sovereign debt. So that was our starting point, and let me now let David take on from there.
What I'll do is just very, very briefly give the sketch, the contours of what we're trying to do in our paper. Our goal in the paper is to take a somewhat different tack than the traditional debt-by-debt approaches to odious debt, or what Anna so wonderfully referred to as micro-parsing approaches, which I wrote down and will probably use again. and to focus on odious regimes rather than odious debts in particular. There are two key points we tried to make in the paper. The first is we try to define what an odious regime is. And the second is we try to suggest a way that we might think about implementing an odious regime policy. And we focus in particular on possible roles that the UN and IMF might play. So very quickly going through each of those. With respect to odious regimes, the thing that struck us, and it was alluded to in the first panel, is in all this debate about odious debt, much of which presumes that we know something about which regimes are odious and which are not, there doesn't seem to be an effort to define what an odious regime is, which struck us as very unusual. As we started trying to come up with a definition, we think we may understand why there's not much in the literature. It's really hard to come up with a good definition of an odious regime, and maybe we didn't do it, but we came up with something that we're at least initially happy with, and that is we focus on, or we define odious regimes as regimes that have either or both of two characteristics. Either one of these would qualify you as an odious regime. One is that they engage in systematic suppression of either their population or a portion of their population. The other is that they engage in systematic looting. The systematic looting, I think, is relatively intuitive. Systematic suppression is not. We talk about systematic suppression a lot more in the paper. We focus in particular on what we call an absence of voice and denial of human rights. The absence of voice idea is designed to get at the intuition that a lot of folks have that being a dictatorship doesn't make you necessarily odious, and being a democracy doesn't necessarily make you non-odious. And so we're trying to come up with a way to think about what makes a regime odious. And we talk about ways that voice may be suppressed. So even if you don't have a vote, if you have very active civil institutions, you have a non-government controlled media, you may have voice within that country and may not be subject to systematic suppression. So we talk about an odious regime as being one that engages either in systematic suppression or systematic looting, or both. And that's a big part of the burden of the paper. The other main thing we try to do in the paper is suggest a way that an odious regime policy might be implemented. We argue that the UN is relatively well positioned to address the systematic suppression problem. And we talk about the possibility that the Security Council would either ex ante or ex post identify regimes as odious. Now, one issue here is one that Dan raised at the outset, I think quite properly, and that is how big is the set of countries that the Security Council is likely to label odious. Dan suggested it might be a null set. We don't think it's a null set, particularly ex post. Ex ante, it's going to be a small set, I think. Ex post, we think it'll be a little bit bigger, and we see this as a limitation, but not necessarily a problem. One of the characteristics of the odious debt, odious regime debate, and the concept, it seems to us, is it is necessarily moral and necessarily political. So any approach to this that purports to take politics out of it, in my view, purports to take morality out of it, is not ultimately going to work, at least as a complete solution. So that's a benefit of the UN, as well as it brings a benefit as well as bringing a limitation. And there's some various further refinements we can make in the discussion if folks want to get into this. With respect to systematic looting, we talk about roles that the IMF could play. Ex ante conditionalities, the IMF could commit not to provide lending into arrears for a nation that's been designated as odious. There are a variety of reasons to think the IMF might be well positioned to engage in this kind of inquiry. The IMF already regularly investigates the members of the IMF. Sovereign debt contracts already have provisions in them them that make it a condition of default for the country not to be in good standing, not to be a member of the IMF. So we think, again, there are a number of difficulties and limitations, but on balance, we think the IMF would be well positioned to deal with or begin to deal with the looting problem. And I'll stop with that.
Okay, thank you, David. Albert.
First of all, I probably should start with a comment that I'm certainly not an expert on odious debt problem. Neither am I. Have I done a lot of research in international law area. The topic of our paper sort of came up during my lunch conversation with Eric a few months ago. That's when I was sort of working on the successor liability problem between two corporations. And I think the gist of our paper is trying to address one specific public welfare argument. So I think, as far as I understand, the argument is that the odious debt regime will provide an incentive to the public to overthrow a dictatorial regime. And also this, in turn, will reduce the incentive of a potential dictator of coming into power. And at least according to Georgetown and Kramer, based on these two observations, they come to the conclusion that the odious debt regime, or imposing the odious debt doctrine, will necessarily improve public welfare. And this exactly is the argument we're trying to tackle in our paper. And our, at least a couple of two different departures at least from Georgetown and Kramer, and some of the other public welfare arguments that have been made, is that, first of all, the dictatorial regime can last oftentimes for a relatively long period, and this actually provides sort of a possible incentive for the dictatorial regimes to engage in a relatively longer-term project as opposed to sort of trying to build a marble palace. And the second thing is the dictatorial regime can be bad, but sometimes can even be worse. And at least a couple of examples we're thinking about is that the dictator can try to extract as much money or welfare from the public as possible using, by, let's say, building palaces for a relatively short-term consumption, or may engage in some possible projects and try to extract wealth using kickbacks and bribes. Our main conclusion here is that the imposition of odious debt regime can sometimes make the dictator or the dictatorial regime relatively more short-sighted, more short-term oriented, especially if the assumption or the conclusion that is made in the traditional argument that this will increase the probability of throwing a dictatorial regime is true, and this can actually lead to provide more incentive to the regime to engage in a worse behavior rather than, let's say, a bad behavior. So this might actually encourage the regime to build a marble palace as opposed to investing the borrowed money into a public project and try to extract wealth through kickbacks and bribes. And finally, therefore, the conclusion we're trying to make in our paper is that if that is true, that imposition of the odious debt regime may not necessarily improve public welfare. And I think I'm going to stop there.
Okay, thank you, Albert. Michele.
My paper sort of proceeds from the view that until we can figure out sort of the role of the sovereign and sort of what the business line of a sovereign should be, that you really can't start to talk about whether it would be good for a sovereign to be able to repudiate its odious debts. So as an insolvency person, a bankruptcy person, I'm focusing in on, I guess, debt more than odious debt. And so I'm trying to I'm working in the paper to figure out what can we do to ensure that the sovereign can continue to operate its business line. So I argue in the paper that the sovereign's business line is to provide services to its citizens. And even though my focus is on insolvency, sort of to use the term that Jim used earlier, my analysis is not incompatible with the global left, but that's sort of not where I'm starting from. most analyses or many analyses of a sovereign in the insolvency context tries to analogize a sovereign to a large business that's profit-seeking, and therefore you borrow money and you have a legal duty to repay the money, and that you shouldn't sort of repudiate and breach your contracts. The difficulty, of course, with suggesting that a sovereign is nothing but a big business, well, there are a number, and I'll just mention three, some of which were touched upon in the first panel. Sovereigns can't be liquidated, so to the extent that you're saying that it's nothing but a big company, well, obviously it's not, because you can't liquidate the company in the traditional sense. The sovereign is going to continue to exist as a person would in an insolvency context, whether or not it can repay its debts or not. Creditors have quite limited rights, can't force a change in management, and as the first panel, I think it was Anna's comments, in fact, you may not want to have new political leaders. You're perfectly happy to have the old political leaders to remain in place. And there are also substantial difficulties at the point of default or when the sovereign is insolvent. If the creditor attempts to sort of protect its rights, you can't seize assets in the country, virtually impossible. And short of luck and happenstance, you may not be able to find assets outside the country. So proceeding from the view, again, that the duty of a sovereign or the sovereign's business line is to provide services to its citizens, I look at three situations in bankruptcy. And so this is somewhat ties back to Dan's point earlier this morning. I'm attempting to use sort of an existing insolvency framework rather than to create a new one because, again, I'm focusing more on debt rather than odious debt. So the three situations that currently exist that I think would justify allowing a debtor to repudiate, a sovereign to repudiate its odious debts. One is equitable subordination, and the reason I'm not going to discuss that one in detail is because that's Adam's paper. Anna's already discussed it, so I cannot talk and stay on schedule and not mention that one. The second one, the other analogy that I would make involves U.S. airlines. As you know, several of the U.S. airlines have filed for bankruptcy, and the main argument that the airlines made in the bankruptcy when they were shedding their pension obligations is basically we can't continue our business line of sort of transporting people from point A to B if we're forced to repay these huge legacy costs, is what they're called. And so even though it was an anathema that workers who had done nothing wrong and had shown up and they'd worked and they'd retired and they thought they were entitled to certain pension benefits, only to find out at the end of the Chapter 11, or actually in the middle of the Chapter 11, that in fact they weren't going to be repaid, the argument was if we think that the debtor has value, that the airline has value, that we're going to allow the debtor to repudiate certain obligations, even though it arguably is inconsistent with federal law ERISA, and even though it's going to cause great harm to employees who've done nothing wrong. The third analogy that I make in the paper, and this is actually a sort of on the consumer side, and it involves student loans, which are presumptively non-dischargeable in bankruptcy. You can only discharge a student loan in bankruptcy if you can prove that forcing the debtor to repay the loan would cause an undue hardship to the debtor. So the argument and sort of the analogy that I make on the sovereign side is if we view the sovereign as the debtor, we view the citizens as the debtor's dependents, that to the extent an argument can be made that it would pose an undue hardship on the dependents, namely the citizens, if the debtor is forced to repay the debt, odious debt, that they should be allowed to repudiate the debts. I'm going to end by the earlier comment about what is odious debt and why does the odious debt doctrine seem never to want to go away. Whatever the doctrine is, it seems to be here to stay. And I would suggest that one benefit that it has is it operates in the shadow of sovereign debt restructurings, just as the threat of bankruptcy or the fear of bankruptcy operates to affect out-of-court workouts. So just as we've seen Ecuador sort of say the word odious, before all of the airlines filed for bankruptcy, they all said the word bankruptcy to try to affect what might happen in the event that they actually had to file.
Thanks, Michelle. Caroline.
Thank you. In thinking about these problems with these despotic leaders and state corruption, and then the economics of odious debt, it seems to me that the easiest way to link the two, and with any luck to at least make some progress in solving the problem, is to try to constrain odious debt, just to make sure that we have as little of it as possible. And in order to do that, I suggest that we might just make some modest extensions to existing common law doctrines and regulatory rules, which will allow us to take into account the existing financial architecture, including the fact that in the international context, it's continually in flux. So in the paper, I take the approach of looking at the sovereign debt markets rather than focusing on whether or not debt might be termed odious or even a regime termed odious. And we know that the debt markets are reasonably well functioning, but certainly there are imperfections in the market related, as is always stated, to the informational asymmetries, particularly, again, when dealing with sovereigns. It's very difficult to know and to disclose all that they might be doing. And of course, coupled with this is obviously a lack of transparency. And we layer onto this the presence of the international financial and development institutions. Then, of course, we have in the private sector the introduction of moral hazard. So it's very easy to go ahead and continue to make loans. There might be somebody else to make sure that you're paid. And finally, of course, there are political pressures that impact the entire markets. So in this focus, what I try to do is come up with ways to make the extensions of the credit more expensive to those who are extending it, in the hope that this ex post liability, these expenses, will limit the incentives to go ahead and make the loans in the first place, and of course ultimately reduce at least the actions of some despotic leaders and the state corruption. So I do this simply by trying to take a look at the different types of loans. And as Anna pointed out, most of the focus, at least in the initial debate, or the debate today, is on these government-to-government loans. And there, as Anna has also pointed out, the political relationships dominate. Those decisions about whether or not to make loans to maybe not a favored country, but certainly a country that you would like to keep in your favor, turn on your strategic concerns rather than any of your financial concerns. And so here, I think we might have some luck in reducing those incentives to try to move into a country and try to keep people favorably by looking at our traditional doctrines of lender liability. And here, I would focus not, as some have, on equitable subordination, because, as has been pointed out, many times the governmental lenders don't expect to be repaid. I would focus on instrumentality and ultimately holding the creditor government liable for at least some of the loans of the odious or the difficult regime. And then moving very quickly into the multilateral loans, there it seems to me that the combination is between the economic factors and the political factors. It's certainly true that the international financial institutions are interested at some level in being repaid. That's part of their mandate, but certainly we know that they are also subjected to political concerns. And so there it seems to me that the doctrine of equitable subordination makes the most sense. It'd be very difficult, even under loose definitions of control, to be able to move to something like instrumentality, whereas if just making it more difficult or less likely that those institutions will be repaid, they may be less inclined to make the loans. Of course, the smallest portion of the market today, but not initially when we were developing the doctrine of odious debt, are the private loans. First we saw, well, it seems we've moved from bonds to commercial bank loans and then back to bonds. And here, I think the important thing is to keep in mind that the financial incentives aren't the same across the lenders. The fiscal agent or the originating agent has different incentives from the members of the syndicate loans. And of course, the underwriters have different financial incentives from those of the bondholders. Importantly, the agents, the underwriters, are paid significant fees on origination, and they earn regular fees from monitoring the debtors. So here I think that the approach makes sense to try to rely on developing new covenants. And these covenants, I think, would just be an expansion of the use of proceeds. Certainly in all the loan documentation and in the bond case where there are prospectuses, what is disclosed are the uses of those proceeds, how the debtor expects to use them. And in the loan context, I would argue that those covenants could in fact be made much more detailed. In the corporate context, the analogy would be the capital expenditure covenants, when in fact the corporation lays out, you've given us this money, here's exactly how we're going to spend it over the next 3 to 5 or 7 years, the length of the loan, and that we could certainly have those same sorts of covenants in the commercial loan agreements. And of course, you could do a similar thing in bond indentures or the fiscal agent agreements, but of course those covenants would have to be a bit broader because they would be monitored only in the capital markets. The trick here is figuring out how to get to that point, right? Because obviously the covenants aren't in the agreements now, and so we would need, in order to move in that direction, something as we've seen in the restructuring movement, which would be some sort of involvement by the government, particularly the U.S. Treasury, sort of pushing for changes. And what would be the benefit? The benefit of having these covenants first in the loan agreements would be that it would be easier with the administrative agent, the lead bank, to track what is happening and to demand regular reports from the debtor. Again, in the corporate context, the typical period is every 30 days. And of course, in the bond context, we wouldn't be seeing that type of review, but of course, there would be securities liability for the disclosures in the underwriting documents. And so if it turns out that the administrative agent isn't properly monitoring now in these detailed covenants, well, of course, the other lenders, the participants in the syndicate will have contractual claims against the lender to try to pull back, at least largely from their pool of capital, but particularly focusing on the fees. And the same would be true in the securities context. With the bonds, there could be securities liability, subject obviously to a due diligence defense for the failure to make sure that things were at least initially going in the right direction. So I think that it would provide at least some mechanism for limiting the advantages that come from lending into these regimes, and the hope that this ex post liability would cause people to pull back a bit. It wouldn't be necessarily as financially lucrative, and at least would limit some of the money. As has been pointed out in most of the papers, the clear problem, of course, is that money is fungible. So if the money came out, if the money were limited that were loaned to these governments, there are, of course, other ways of getting money through taxes and things of that nature. So I'm not suggesting that this would be a panacea, nor am I suggesting that it wouldn't be costly. This would, of course, involve a case-by-case analysis of the debt, and of course, initially, at least at the commercial and bond level, there would have to be some official sector involvement to move to those terms. But it is at least a way of beginning to move while we figure out what odious debt is, or what an odious regime is, or what the right approach is, to at least limit the odiousness that's happening in the interim.
Okay, thanks, Caroline. Kunibert.
Thank you very much. The crystal clear perception and understanding of odious debts we are talking about was made even more so by the Norwegian government that introduced a new category, illegitimate debts, without any definition. And it was further sharpened by the action of reducing debts from the so-called ship export campaign. That's some years ago. In this occasion, they accused themselves of a lot of things they shouldn't have done, but they refused to use either the word illegitimate or the word odious, so that we don't know what this kind of improper debts really are according to the Norwegian government itself. Now, what could illegitimate debts be? And in my paper, I tried to make a distinction between two categories. The one is what I call illegal debts, These are debts that contravene either the law, as it is in some jurisdictions, or some basic principles of any legal system. Now, in all jurisdictions, for instance, we have the principle that a physical person signing for a legal personality has to have the authority to do this. This was not always observed in the case of sovereign debts. Such a debt, I think, it can hardly be argued should be anything else but void, because those signing had no authority to do this. One could, to give another example, say that, for instance, if multilateral institutions give advice, act as consultants, be the knowledge bank without appropriate due diligence, then something like a tort or compensation law should come into effect. Third thing, which I think is rather beyond discussion, if an international institution breaches its own articles of agreement and inflicts damage in this way on their members, they should be held responsible. And one example, which was already mentioned by Shari before, was the Asian crisis. According to the articles of agreement, the IMF is, a member of the IMF is not allowed to use IMF money to finance a sustained outflow of, a large and sustained outflow of capital. And the IMF may, need not, but may ask a member to stop doing so. Now, in breach of their own constitution, the IMF did exactly the opposite, financing this outflow of speculative money from Asia and inflicted damage on the Asians. And to bridge the difference between odious and corruption, the International Bank for Reconstruction and Development is known to have, over many years, given loans to Indonesia, fully knowing that something like a quarter or a third would disappear in the pockets of Suharto. Now, not being a lawyer, I don't know why aiding and abetting comes to my mind all the time, but whatever it is, it was not a proper way of dealing with it. The second point are debts that might, legally speaking, be correct by strictly formal standards, but where there are some reasons why people are uneasy about their existence. Now, gambling debts in national jurisdictions is one example where one tries to restrict the possibility of cashing them. One could refer to the principle ex turpi causa non oritur actur. And this is the second and more difficult part, where I think it's much more difficult to come to a conclusion or to come to an agreement. An important point I would like to make is that distinguishing debts is not only in the interest of the debtor, but also in the interest of bona fide creditors. And this is what I try to explain with a very simple example in my conclusions. The very simple example is take a country having debts of, say, 100 and a payment capacity of only 50. That would mean that if you had a reduction that removes the debt overhang, for instance, in an international insolvency, as I have proposed it, then everyone would get half of their claims. However, if 40 were debts that are void or don't have to be paid for whichever reason, then only 60 would remain in valid claims, which would mean that all the bona fide creditors would get 80%. Therefore, I think the question which has been raised, are such arrangements also in the interest of creditors? I would say yes. If you are a bona fide creditor, you should be very happy about such an arrangement. And such arrangements of recognizing legal principles were there in the 19th century. There, for instance, ultra vires was applied. It was checked whether these guys had the authority to sign. Or if you take the Tinoco case, if the creditor knew, or it was reasonable to assume that they had known that the money was not used for a proper purpose, was embezzled by the dictator, then they would not get their money back. And seen from that way, we are today beyond the 19th century. Not in the sense of an improvement, but in a sense that today, regarding debts, we still are a bit in the perception that grain is whatever comes to the mill. And I think we should have a certain distinction between what is grain and what isn't grain. Thank you.
Okay, thank you, Kunibert. And Tom.
Thanks, Dan. I want to begin by thanking Mitsu and Anne and Kimberly and the student editors of Law and Contemporary Problems for the invitation and arrangements they have made. My paper is co-authored with Tom Ginsberg, my colleague at the University of Illinois College of Law. And as will become evident, he's the brains of this collaboration. I wish he was here, and I'll refer most questions you put to me to him. Let me very briefly summarize our paper, and I hope that in doing so you'll see the portions of overlap with other papers that have been presented here. We begin by considering three possible solutions to the problem of odious debt. And by the problem of odious debt, we mean principally the fact that successor democratic regimes might be stressed to the point of failure by obligations to repay sovereign debt of a prior non-democratic regime. The three solutions that we identify are, first of all, to do nothing, to let politics work out support for the democratic successor regime through renegotiation, for example. Secondly, some sort of ex-ante regime under which sovereign debt would be identified as odious before it is extended. And the third possible solution we characterize as an ex-post regime in which there would be some mechanism by which to identify all or some portion of sovereign debt incurred by a despotic regime after it has been succeeded, presumably with a view to excusing the democratic successor regime from the obligation to repay that portion or all of the sovereign debt. We find that each one of these proposed solutions is unsatisfactory. For example, with regard to the do-nothing possibility, the greatest flaw we find with this is that it might work, but it might not. And we'd rather try to consider some solutions that have a greater likelihood of achieving the end in mind. The principal problems we find with both the ex-ante and the ex-post solutions to the odious debt problem are problems of administrability, many of which have been touched on by prior speakers. And so we believe that there is a case to be made for a new sort of solution. Before I get to that, and in passing, I want to at least mention a complication that we introduce, and that's the problem of the odious creditor. An example is China's very favorable loans to the Sudan, an odious regime, and China's threat to prevent any UN sanctions against Sudan in pursuit of a policy of stopping genocide in Darfur. Why do we introduce this idea of the odious creditor? Because it seems to us to emphasize that international political considerations are a central problem of the problem of odious debt. It reminds me that a wise person once said to me that there are really only two things you can say about a problem. One is, you say it's quite simple, but it's really quite complex. The other is, you say it's quite complex, but it's really quite simple. So, what to do? We begin our search for a solution by recognition of four things that we think are, that will command widespread respect. First, we recognize the inadequacy of prior proposals for solutions, as I've indicated. Secondly, we recognize the great value of preserving the general commitment in international law to the obligations of sovereign debt. Third, we recognize the great importance to the world of economic growth widely distributed in the world. And finally, we recognize the unavoidable political dimensions of the problem of odious debt. So here's our solution, which I'll try to elaborate shortly after I conclude my remarks and you start asking questions. We think that developing countries, successor regimes, ought to be allowed to repudiate sovereign debt incurred by a despotic prior regime, and if they can make a successful case to the IFIs, international financial institutions, that debt was in fact odious, the IFIs will offer them insurance for repayment of future sovereign debt for the defaulter. We think that this proposal will put the burden on the developing countries of coming forward and making that case, either for partial or complete repudiation of a prior regime's sovereign debt, but it will preserve the possibility that will not damage them in future borrowings on the international capital markets. Thanks, and I look forward to the discussion.
Thank you, Tom. First off, does anybody want to make any follow-up comments, either on their own comments in response to what others have said or in response to others' comments? Tom, you just finished, but you can start again.
He's on a new time clock now. So you've got 32 minutes for this part.
Albert, could I ask you to elaborate your and Eric's proposal about, it went by too fast for me, about why it is that allowing repudiation would encourage, I understood you to say, would encourage despotic regimes to misbehave even worse than they might do without repudiation.
Well, I think the proposal, so the general aim of the paper was to sort of try to focus on the behavior of the dictator once he or she comes into power. Now, if it is true that the imposition of the odious debt doctrine will increase the probability of the dictator being overthrown in the near future, this, in terms of, let's say, different kinds of project selection that the dictator might be able to engage in, he or she is going to be much more inclined to extract wealth from the public immediately as opposed to engaging some other behavior that might give him a longer-term return. So I think that exactly is the basic trade-off we're looking at. Why is this? This sounds like such a simple story, but at least according to some of the papers we have seen, including Chandra and Kramer, they don't necessarily look at the long-term prospects of the dictator. I mean, the dictator either comes into power, is gone next period. So there isn't any sort of scope of the potential, let's say, moral hazard problem that the dictator might engage in.
And David, did you want to?
I just wanted to throw out a general point or comment or issue, and that is one thing that seems to be lurking beneath a lot of the discussion is an equation of odious debt or odious regime and debt overhang. And one question I think that's worth talking about at some point is, are we only worried about debt overhang, or is odious debt separate? This, in a sense, is the Venn diagram that Dan started us out with. And my own instinct on this, or my own belief on this, is they really ought to be completely separate. That if we're serious about odious debt doctrine, it ought not be about whether there's a debt overhang problem or not. There often will be a debt overhang problem, but in my view, that should not be a necessary precondition. And if you look back to some of the historical antecedents, which we've already debated about a little bit, most of them were not debt overhang problems. America and Cuban debt, it was not, we could have paid that debt if we had wanted to, but we didn't want to. So I just wanted, I guess in a way, to reintroduce that issue because it seems to be running around in all of our comments.
Okay. So I'm going to suggest that we up here at least get started by considering the relationship between the ex post effects of whatever it is that people want to put into place and how that affects people's behavior ex ante. And maybe we can separate between the regimes, or the dictators, the despots, on the one hand, and the creditors on the other. And I want to start with the creditors, because in the first session we sort of slipped by, but suggested, there was a suggestion that there was a pretty direct relationship between sort of such institutional mechanisms as did or did not exist, such as workout procedures, and the relative remuneration associated with lending to sovereigns. And that, I think, raises the larger question of how much here makes a difference. I mean, where is the direct relationship between the things we put in place to deal with odious debt, however defined, afterwards, and the impact on the initial lending behavior, particularly in light of what Bob Rasmussen said earlier today about the multiple times in which there will be decomposition of whatever instrument it is. You'll have guys with credit default swaps and all the rest. Patrick, maybe I could ask if you would start.
Yeah, let me start with that. So I think there is a real concern that if a odious debt policy is implemented that's too broad, too vague, and too far-reaching, this will have a major impact on cost of borrowing for emerging market countries. And I think that's particularly a concern when one takes a debt-by-debt approach. Because it's very difficult when you're lending, very difficult to know whether, even on an ex-ante basis, even when you've done your due diligence, whether this is going to be shown to be odious debt ex post. You're going to put in a premium just for that reason. So I think it's important to bear that cost in mind, and that's one reason why we think that what's appropriate is a policy of odious regimes where the regimes are truly odious. These are the exceptions. These are regimes that are beyond anything, have gone beyond any standard of decency or respect for human rights. Those are the regimes we want to target. I think we don't want to have a policy where just because it's administrability concerns, we let them off the hook. I think we have to deal with the truly awful regimes, the Cambodia, Khmer Rouge, the Nazis, Nazi Germany, South Africa apartheid, and so on. We just can't avoid dealing with those regimes. So I think we want an odious regime policy, but it should be focused on those precisely because you're worried about the externalities on all the other borrowers who are borrowing for legitimate reasons and who will then just have incur a higher cost of capital.
And David, I take it that's at least one of the thoughts behind the observation you just made a minute ago of wanting to specify the odious debt problem rather more precisely and not let it elide so much into the general problem?
That's a big part of it. The other piece of the analysis is if what we're really concerned about is debt overhang, we should be worrying about sovereign bankruptcy and CACs, as we were 5 years ago. And that's if that's our real concern, there are better ways to address it than through an odious debt doctrine, is the other piece.
Okay. Other comments on this issue of the impact on investor behavior? Maybe even before, maybe I can turn to the audience for that before we turn back to the regimes.
Can I ask a question?
Sure, Michelle, go ahead.
I wonder if it matters who the investor is, and this somewhat harkens back to the discussion in the first panel. Would it matter if it's a nation to nation, so the creditor is another sovereign, as opposed to the creditor being a private lender? Because a lot of what we've said in this panel and so far today may change depending on, for example, how much information you have with respect to which loans are how the loans are being used. That may vary depending on whether or not it's the Saudi government as opposed to a private bank. So I just sort of add that to when we say investor, I wonder if we need to be somewhat more nuanced in who the investor is.
My own thought, for what it's worth, is that there would certainly be a distinction in how a particular institutional mechanism affected the incentive structure of the creditor, depending on whether the creditor was a private, more or less profit-maximizing actor or a government, for the reasons that Anna said this morning, which she and I are both skeptical that much of which passes under the name debt when it comes bilaterally is conceived of with anything like a traditional notion of debt underlying it. But others may have a different view on that. Okay. Let me go to Melissa first.
I think this follows on the broader question that you were asking here, and it picks up on this question of separating debt overhang and odious debt, which is the remedial question, which came up in some of the comments, but maybe not all of them. If you were committed to only capturing or targeting odious debt, and not only in a debt overhang situation, we shouldn't so much care if it already has been paid and should be interested in recapturing it versus only trying to find a way to forgive it while it's still outstanding. If you don't end up drawing that distinction, you create incentives to structure these lending agreements in different ways or make them not look like debt at all, picking up a little on what Anna was getting at.
Well, that's a very good question. If, on your point, David, if we're zeroing in on the odiousness of the transaction as such, then why should it make a difference whether the debt has been repaid, the debt to build the palace has been repaid, or whether it's still outstanding? And obviously, if you take Melissa's intuition and push it further, you're getting into having to chase assets around the world this way, right?
Well, that's the problem, I think, with Melissa's intuition. I think it's a great intuition. I think it's very interesting, and I'm sympathetic to it. The question would be, you're multiplying the administrability issue. It's essentially like the reach-back provisions that a lot of bankruptcy systems have, and this would be a different iteration of it. Conceptually, I like the idea, and I don't know if I can't bind Patrick to that, but I like it
See,
conceptually.
when Patrick shows up, David can't bind him.
It changes the dynamic, there's no question about that. Yeah, we need a silent third co-author. We'll just make him up.
Sitting here.
Well, that's the problem. We want someone who's not sitting here. Tom beat us on that. Conceptually, I like the idea. It seems to ratchet up the administration problems, but I don't know, Patrick, do you?
So that's I can't react that quickly, but to the extent that this is relevant, so one of the points we make in our paper is that one advantage of an odious regime policy, let's say the UN declares a particular regime as odious, one advantage of that is that it opens up the possibility for victims of the regime to sue for some form of compensation. And I think maybe that relates to what you're saying.
Okay. Albert, go ahead.
Can I just ask you a question about this odious regime?
Oh, no. Okay. Can you hold on just a second with the
sure.
regimes? Because I want to try to stay with the creditors just for a couple of minutes. You were on the creditors?
I was on the regime.
Okay, hold on. Bob, you're on the creditors?
I'm just talking about Melissa's point. Why isn't that just an embargo on investment then? Why isn't it if we have a reach back? Why isn't that? Wasn't it function to say better? We just have a regime that says you can't make foreign investments in odious regimes.
In effect, I think it's quite similar.
It's basically an embargo on capital inflows.
Yeah.
Well,
Right, I think
let
it
me-
is.
That's what it collapses into, right?
So, but Melissa does.
Let me just say that my point was more trying to characterize what it means to disaggregate debt overhang from odious debt. I don't necessarily advocate for it, but I think that conceptually there shouldn't be a distinction between the debts outstanding already versus.
Right, and then you just get to borrowing investments. It's not really an ex post problem of what you do with debt. It's an ex ante problem of, just getting governments or whatever the mechanism is to say, just ban investment expressly.
That certainly takes care of the incentive problem, doesn't it? Anna, you were on the creditor incentive issue?
Very briefly on the creditors, going back to Bob's point, but expanding it, he's sort of gotten us in a terrible conundrum. You really can't look at the creditors too much because Germany sold off the debt Russia owed it to private creditors. It was odious on day one, not odious on day two. You see Venezuela, Ecuador, and all of that. So how do you deal with that? Do you do it, if you take creditors into account, do you do it by snapshot? At the moment the transaction is originated, at the moment of their restructuring, we don't care what the economic interests are. We're going to have some kind of a formal rule. If you're at the table with this nameplate, these are the consequences that are going to flow. I think there's a serious issue with zeroing in on the creditor because of the flow, because of the change.
That's the same issue now, right? That's the issue now, like right now. Yeah.
And it's getting worse. In the sovereign world, it's going in both directions, right? It's going from private to sovereign to private debt.
Okay, so now let's turn to the regimes. We didn't solve creditors, but we got some issues on the table. Now let's go to regimes. And Albert, your question.
Yeah, I mean,
Because we're going to solve regimes.
let me just add in another layer of complexity. Maybe you addressed this issue in your paper, but I mean, at least a couple of examples that come to my mind are, let's say, the Chilean government under Pinochet and the South Korean government under Park. I mean, these were very repressive, lots and lots of human rights violations. But at the same time, they're achieving, I don't know, 10% economic growth for 10 years, and they're at the same time borrowing huge sums of money from abroad. I mean, how do you deal with governments as such? And I presume that, I'm not sure whether the Chinese government is borrowing a lot of money at the moment, but, at least to the extent
They're
that the
lending a
political
lot.
concerns are, at least to the extent that the political concerns are sometimes separate from the economic concerns, how do you, where does your test, how does your test try to deal with these problems?
So maybe, David, if you allow me to respond
Absolutely.
first. So,
I thought for a second you were going to allow me.
I think it's a very good question. I think it relates to your concerns about having a flexible approach to odious regimes. And our answer to that is that it really matters who the decision maker is. This is why we put so much emphasis on the UN Security Council. That's exactly the kind of discussion and this decision-making analysis that the Security Council will be involved in. So let's take Chile's Pinochet regime. Well, maybe the U.S. will think this is a very precious ally. They're not doing so badly. No way we will agree to a decision to brand them odious, right? So that's the limitation of the policy, but it focuses squarely on the political question. So there are very extreme regimes that will be singled out. Like I think Cambodia's Khmer Rouge might be an example of an extreme regime, or Rwanda's Hutu regime. So that's the hope that you really target the clear, most odious regimes, and that you're able to do it. I mean, we don't know, but that's the hope. Obviously, the more intermediate cases, it's a matter of careful judgment.
Well, I mean, if you're advocating some sort of case-by-case basis on the classification of regimes, doesn't that necessarily recreate the uncertainty in the financial market? And which is one of the things you're
That's what I'm saying.
concerned
So
about.
that's what I said earlier. It doesn't create. It reduces uncertainty, because the financial markets will understand that only the most extreme regimes will be targeted, right? So that your typical borrower will basically not be considered to be odious.
Tom.
David and Patrick, I'm worried about your proposal to have the UN, particularly the Security Council, play a role in designation of this, precisely for the problem that we mentioned in our paper about the odious creditor. Suppose that somebody succeeds the Sudanese government, and it's the successor regime is somebody that there's common consensus is a far better.
Caroline, could you push that mic closer to? There we go, thanks.
Is a far better regime than the one that they succeeded. China is the principal creditor of the old regime. Why would they allow repudiation of the debt that's owed to them by a vote designating the prior regime an odious regime in the Security Council?
Well, thanks a lot, Patrick. I incorporate Patrick's prior answer. No, I mean, these are hard questions. My guess is that ex post, you're going to have fewer of those China-Sudan examples, or that there'll be, ex post, you will get some agreement on who's odious. Nazi Germany being a classic kind of example. But there's no question that this approach is going to have some false negatives. And I guess our intuition is, if you're either going to have false negatives or false positives, we think it's really important for all the reasons we've been talking about, markets, politics, that you have false negatives rather than false positives. And I think we're going to get true positives.
David, let me follow up on Tom's question on that point, because I understand and sympathize with what you and Patrick are trying to do, which is to confine the potential effects of this so that it doesn't bleed over into unwanted consequences. But if you really are saying it's going to be a very small number of cases, and they're going to be only in retrospect with the passage of some history, will we be able to garner a sufficient international consensus? At that point, is it reasonable to think you're going to have any effect upon creditor or dictatorial behavior ex ante? Because aren't they basically, this thing is such, it's down there in history somewhere. It's not going to be very many cases. And I'm not going to, I've got many things to worry about, like the assassins outside the gate. I'm not going to particularly worry about whether the UN Security Council in 10 years is going to say, you were an odious fellow.
Go ahead. Oh, sorry. Yeah. So I think it's a serious limitation. Nevertheless, it's an improvement over doing nothing.
Okay.
I would argue. Maybe you want to do more. I think financial markets, even if the branding of a regime as odious is far into the future, way past the time when the regime was in place, financial markets will take that into account when they see the situation deteriorate. They will anticipate that maybe their debts won't be repaid, and so you'll see that reflected in the cost of debt.
Okay.
For those.
Kunibert.
Yes, one short remark about Chile, which has been named quite often. Not all the debts of the odious regime, if you wish, of the generals were actually borrowed by them. Because at the beginning, when the IMF encouraged them to liberalize, as they later did in Asia, the regime said, go on, have the private market, but if there is a crash, we are not going to bail you out. But they were forced to retroactively guarantee, I think is the proper term used by the World Bank, to practically pay for what had gone wrong in the private market. And then they were suddenly faced with having debts they never had borrowed in the first place.
Okay, so now on the regime and regime incentives and effect on behavior issue. Yeah.
My question, I like the idea of not doing debt by debt because money is fungible, but I wonder if an odious regime is year by year instead of debt by debt, right? So an odious regime isn't always odious. And so it becomes odious, and then maybe it's not odious. And then you add that into these sort of political UN stuff that I know absolutely nothing about, but it doesn't seem like you reduce the uncertainty all that much, because now instead of just doing it cross-sectionally, you've done it temporally. And there's no incentive to not be odious. Like, once you're an odious regime, you might as well just go ahead and kick back and be an odious regime because you've been labeled.
Really be odious now.
And that might be related to Albert's point.
So we discussed this point in the paper. So obviously you don't want that there. You don't want a country to be able to write off its debts by just allowing for a brief period of an odious regime. So it's important to separate the debts that were incurred by the country prior to the arrival of the odious regime and the debts incurred by the odious regime. So what we're saying is that the debts that were pre-existing should not be canceled.
But my point is that the regime itself doesn't start out oppressing its people. It starts out pretty okay, and then it oppresses them.
That's right. And so the point is that on a flow basis, that regime will quickly realize that its new debts it's incurring will come at a much higher and higher cost of debt.
Jeffrey.
I'm wondering on this use of the Security Council, not only do you have the problem in terms of the consensus requirement from the P5 countries, but also you have an issue in some cases, some odious regimes, of whether or not the Chapter 7 threat to peace and security is met by the odious conduct. And I'm wondering, why not think a little bit smaller in terms of authorizing or using the General Assembly as essentially the bellwether for making determinations by vote, not subject obviously to a veto requirement, of regime that is odious, and making that determination. Essentially, it's like the human rights reports that the State Department, I'm sure Dan would tell us about that, does on a year-by-year basis, and to create, in other words, essentially a norm. It's not going to be binding. Neither are Security Council resolutions. They're technically binding under Article 25, but are they really followed by the countries? We know that they aren't always followed by the countries. So if you want a device for having an expression of a norm, it seems like you could go through, without dealing with the Security Council issues and the veto issues, you could go through, and having a broader base of countries voting, you could do it through the General Assembly. And this goes a bit to the whole complaint about, well, a lot of these debts are public. Then the issue, or publicly owned, and therefore the resolution of the matter is a political one. I think the next step then is not to throw up our hands and say, well, it's just political, but what are going to be the norms that shape how countries talk to one another about those odious infection issues of the debt?
I mean, I would actually love to sort of turn that around, throw that out as a question/comment to see what other people think. I don't know enough about the UN to know how plausible that strategy is. My sense is that these kinds of really big, morally laden, politically laden issues tend to go to the Security Council. I mean, it'd be a little hard to imagine the General Assembly making a decision on genocide, for instance. But maybe that's wrong, and I like your idea. I'd be very interested to hear what other folks have to say who actually
Well, I'll make
know.
one prediction. If it goes to the General Assembly, the first odious regime in the world?
Is the U.S.
United States of America. That's right. That is right.
That's a good.
But Jeffrey raises a very important point, which I was inadvertently allowing to slip by, which is the legal effect of whatever determination is made by whoever makes it. And you made the very important point that a Security Council resolution, even one taken in accordance with its existing powers under the UN Charter, does not work its way into domestic legal systems. And so in the absence of some sort of other institutional change, it just sits out there. And when you talked about a norm from the General Assembly, in many respects, I think that's what a Security Council resolution is as well, but now we got a bunch of people leak.
Is there not a possible perversity here? Let us suppose that you succeed in painting a scarlet red O on the face of every odious regime. And let us suppose that Patrick's right, which he surely is, that the consequence of that would be to raise precipitously the borrowing costs of that regime. Why? Because the lender is now on notice that if the regime changes, he loses his right to enforce his debt. Yeah? Aren't you betting that the odious regime changes quickly? Because unless you shut off all lending to that regime, what you're really saying is that the current population of the country will hemorrhage in debt service costs as a result of these increased coupons. Now, Mr. Marcos stayed around for 20 years. The Soviets stayed around for 80 years. Some of these regimes hang on a long, long time. And so what you're saying, you're almost offering them a kind of religious proposition, which is to say, under our new administration of this problem, your redemption, your ability to repudiate will come in the afterlife. We can't tell you when, but until you reach that, this is a vale of tears, and the current population will wind up paying for that future redemption.
That's very well put, Lee.
You'll be happy to know that we quote
always,
your Scarlet O in our paper.
That's absolutely right. That's the dilemma you face with any kind of sanction. That's not specific to the odious debt. Any kind of sanction regime, you worry who's going to bear the burden of that. Is it the population or is it the regime? There are ways of addressing it. They're highly imperfect. The UN has a lot of experience with that. The Oil for Food program for Iraq was a compromise precisely trying to address this issue. So I think that speaks even more for the UN being the right venue for an odious regime policy.
Okay. Let's see, right here in front.
Yeah, this is in a way picked up by Scott's question. So I like the idea that we want to try to define this narrowly, so we don't have this tit for tat game of everybody saying, "Oh, well, you're odious." In reality, especially if we think about this in the UN Security Council, I think that we're not then going to have nations that have looted or nations that have suppressed, because the ones that have looted will probably have borrowed from countries like China or the United States or the Soviet Union, Russia, etc. So the UN Security Council will knock that out. So in reality, my suspicion is the universe of odious regimes is going to be really quite small, and it's actually going to be countries that have basically massacred their citizens, and there will be some agreement, not merely suppression, right? Rwanda, Pol Pot, not many other historical examples. I don't think Myanmar is going to work because Myanmar will have borrowed from China or Russia, etc. But now if we're talking about that smaller universe, those massacring regimes tend actually not to borrow a lot and not to last very long because it's really, really bloody and someone else comes in and overwhelms them. So what happened in Rwanda? I'd be curious if the Hutu regime that existed, overseeing the massacre in Rwanda, borrowed anything. Because the massacre happened and then they got overwhelmed by soldiers coming in from Burundi. I don't know how much Pol Pot borrowed, right? He was too busy killing people. So I like the idea of the narrowing. I'm wondering if we're narrowing it so it's now merely a theoretical construct where the only way we'll ever get it through is for a regime that in reality will have borrowed maybe 50 cents.
I'll give an initial answer, and then Patrick will give the, well, I won't say that.
The ones he knows the answers to, he answers.
That's right, yeah, we sort of, we churn and then we answer. So I will churn. If you get down to, if you get down to just that small subset of regimes, maybe we haven't advanced the ball. But again, I go back to the point Patrick made earlier: is are we better off trying to do that than we are not trying to do that? I think yes, and I should probably emphasize that we don't view our approach as preclusive of other approaches. We'll be talking a lot more about the debt-by-debt approaches using domestic courts and other institutions. I think those all have significant problems with them, but they're not inconsistent with our approach at all. I think we should be working on these things together. I don't think the subset of countries that would be labeled odious would be quite that small. I think a country like South Africa, ex post, you might be able to get agreement on them being odious. And so I think there are some other countries that even under a politicized decision-making process, you would declare odious that didn't engage in that kind of massacre. But I think that's an issue. Is the set so small that it's not going to be useful?
Right
Patrick,
here. Yeah.
No.
Oh,
I'm
let me go to
Yeah.
Ann. I extracted 5 minutes from Ann, but that's all we're getting. Okay. So let's try to take a couple of, please, very quick questions from the floor, very quick, and then go to Albert and anything else anybody else wants to say. Yes, go ahead.
Very quick question. I'm struck by something that's come across this entire panel and the panel before it, and it can be boiled down to a question of ulterior motives. It seems that when you take the aggregate of things that have been said here so far, and probably through the end of the day, we are now creating or talking about this odious debt as sort of a horse with many saddles. And it's not clear just exactly which saddle you mean to put on this horse when. Are we talking about odious debt in terms of imposing democratic regimes as a universal goal, and this is merely an instrumentalist approach to getting there? Is this an instrumental approach to make regime change more efficient? Are we talking merely about the financial mechanics of repayment or the protection of private global capital markets at the expense of either the lender side or the borrower side? Or are we really talking about odious debt as a program of coercive harmonization, either of human rights norms or economic norms or the like? But it seems that to the extent you mean to use this for all of the above or some of the above, the inherent ambiguities become insurmountable.
Well, let me just, before I take the other quick comments, I think David and Patrick have been quite clear that they are trying to carve out a discrete area and not cover everything. Okay, let's say Tai Hang.
Just a quick comment, even as to the narrow carve-out, and even assuming that the narrow carve-out would apply to beyond situations of extreme situations such as genocide, I'm concerned that there may be situations of an oppressive regime in which you don't want to increase the cost of lending and you want to continue having capital flow in, because, for example, if that regime was imploding and had weapons of mass destruction or biological weapons, permitting that regime to completely implode would unleash a reign of terror on the world. And I wonder whether that concern can be worked into.
But although these guys, I know what these guys are going to say. they can turn to me. They're going to say, in that case, you wouldn't get the determination because there'd be a more nuanced view by the world community. Bob.
Can I talk about the proposals real quick that were made? Like Tom asked about your proposal for a second. First, you seem there's an on-off switch in the sense that we go from a bad regime to a good regime. I'm worried about it's more nuanced than that. So if you provide insurance to the new regime, isn't there a moral hazard problem that since the new regime has insurance, it's going to slide back toward the other? So it lets us think. And then for Caroline, my question is, I'm a little uncertain how the covenant mechanism works in that you allow waivers. I mean, because covenants aren't binding. Covenants are just a starting point for discussions and maybe more fees paid. So I was curious about, are these binding covenants or can they be waived by the syndicate?
Okay, last question from the floor is Jim.
These are two things that sort of follow on other things that people have mentioned. But one is just a question about your paper for David and Patrick. If an odious regime is labeled as odious, will that absolve it from any repayment even if there's a benefit? I mean, the burden and benefit analysis that was part of the original odious debt mantra assumed that if even an odious regime had actually used the proceeds of loans to benefit its people, that then those were legitimate debts which had to be repaid by successor regimes. So I hope that's part of the... and then tying on from what Tai Hang just said, be careful what you wish for in terms of getting the costs up and locking people out of the international borrowing market. China, the bad creditor, odious creditor example, is a case. This is more environmental than in other areas, but I think it has some spillover for this, where they saw what happened to India with the Narmada Dam and environmental oversight by the World Bank. So they said, fine, and this is a time when China was less flush than it is today. We're going to build it completely with our own money, so we evade any oversight by international agencies that may complain about our environmental practices.
Okay.
And is that a good thing?
Good. All right, now in complete arbitrariness, I'm going to suggest that the covenant issue that Bob raised get deferred to one of the discussions this afternoon where a lot of these private law analogies are coming in, so I'm throwing it on you, Brother Bookite. Number one. Number two, I'm gonna ask if Tom wants to very quickly respond on the moral hazard issue and then give Albert the last word and then we can go. Okay, go ahead, Tom.
I'd rather defer till this afternoon. It's a very good question. I want to think about it.
Okay, all right, fair enough. Albert.
Well, I guess maybe
better
I
be
can make
good
a
now.
very
Understand that.
small observation. I mean, if you're trying to make the category of odious regimes very small, if we're sort of trying to provide two different incentives. The first incentive is to provide the incentive to the current population to more likely overthrow the dictatorial regime. And the second incentive is a potential dictator, discouraging potential dictator from coming to power. If the odious regime is so small, I would presume, I mean, what sort of an impact will the imposition of odious debt doctrine will actually have in terms of solving any of these incentive problems? I would presume that it's actually going to be the intermediate cases where the cases it's much, much more difficult to determine whether the regime is odious or not. That's where we're going to might have a lot more the incentive bang for the buck.
Good. Okay. Thank you, Albert. Thank you, everybody. I don't know what we're doing now. I guess we are, but I don't know what the instructions are. Oh, Anne, are you going to instruct people? Good to see you again.
Yeah, good to see you again.
All the panelists and faculty and guests are
visit
invited
there?
to
Why do I
attend
associate
lunch in the
you with-
Birdman Lounge right now. Everybody else, we hope that you'll come back and join us at 1:15. Thank you.
I thought you had gone there already. Or did, for some reason